thus incorporating the revenue sharing range of 5% to 7.5%, and two alternative rates of interest, mora interest or interest in terms of Section 2A5 of the Prescribed Rate of Interest Act. The alternatives in the order translate to huge differences in the amounts payable across the revenue sharing range and between the interest calculated on the alternative basis. If the Supreme Court of Appeal had properly considered the relief, it would have realized that although a litigant can claim relief across a range or in the alternative, a court has to fix the relief with precision. The purpose of giving these few examples is to illustrate that the Supreme Court of Appeal, A, failed to provide adequate reasons for its judgment, B, disregarded or was unaware of certain material facts and issues before it, C, at times merely highlighted the parties' arguments in respect of central issues but did not engage with those arguments in any meaningful way, D, failed to assess evidence that was adduced by the evidence which it ought to have assessed, and E, readily accepted whatever Mr. Makate proffered without explaining why it did so. Based on these holdings, I conclude that the Supreme Court of Appeal failed to discharge the duty of proper consideration. This failure violates the rule of law and the fair hearing right protected in Section 4 of the Constitution. Must we deal with the ground of appeal on the lack of a cross appeal? Ordinarily, we would not have to. That is so because what I've just held on the failure of justice point is dispositive of the appeal. But I feel that this court must have the last word on this ground. That is so because the manner in which the Supreme Court of Appeal dealt with the issue underlying this ground, i.e. upsetting the order being appealed on an issue in respect of which there was no cross appeal, will be considered binding